right, welcome back. I'd like to welcome Robin Freeman, a local attorney, as well as a colleague of Caroline who we saw this morning. So he's going to talk to us about some of the more practical concerns about Act 35. So I'll let him introduce himself and get started.
Hi, good afternoon. As Sarah said, I'm Robin Freeman. I am a colleague of Caroline Earls. I work with her at her firm across the street. And from what I've been told from Caroline, apparently I have all of the answers to all of the questions that you might have. Fair warning, I do not do any puppet shows, so we won't have any of the puppet shows coming this afternoon, but I'll try to answer whatever questions you have. I'm going to start talking with some of the slides that I prepared with a couple of the practical concerns that might come along with Act 35, including informed consent. And Sarah mentioned to us before that there are some folks in the room that are either school guidance counselors or do work at school districts. And so there's some additional issues that you should be aware of because of FERPA concerns. So I'll talk about that. And then after I'm done with the slides, we can talk about any other potential issues that you might want to talk about with Act 35, such as who pays. We can run through some hypotheticals, whatever questions you folks might have. So we'll start off with informed consent. Of course, the statute for Act 35 doesn't define informed consent because why would they do that? That would just make it easier. So I will look at some other statutory examples that you can find in the Vermont statutes that do define informed consent a little bit. Of course, we all have kind of an understanding of what best practice would be for informed consent, but the statute does define it in certain places. For instance, for the mental health treatment, the inpatient mental health treatment, if the minor is over the age of 14, there is an informed consent statute. It doesn't define exactly what informed consent is. However, it does say that the informed consent does have to include that the patient will be in inpatient status, that they desire to be admitted to a hospital, that they're consenting to be treated voluntarily. So there's some extra language that needs to be included into the form under that statute. For the advanced directives, which is more of a legal issue, it's just a very simple informed consent means consent given voluntarily, so on and so forth, after being fully informed of the nature, benefits, risks, and so on. So the question, of course, to that is, what does fully informed mean? And this statute doesn't actually define that because, you know, as lawyers, we have to have something to do. So we're going to argue about what fully informed means and whether or not you've met it. A couple other examples. This is the voluntary sterilization statute, which hopefully is not used very often anymore. However, the interesting thing in this statute is the section B, right in the middle. Physician is satisfied that consent is based on the understanding of that information and that before the operation is undertaken, the physician personally obtains evidence of the person's retention of that understanding not less than 10 days following the original explanation. So with voluntary sterilization, one interesting part is that you actually have to obtain informed consent twice, and they have to be at least 10 days apart. However, for the purposes of Act 35, I think that this particular section of the statute is something that you would more model your informed consent forms around and your informed consent of minors, because this statute is specifically talking about making sure that the patient has understood what informed consent is, and that you as the clinician or the treatment provider have satisfied yourself that the person has understood what you're saying. Now, I, as a lawyer, I can't tell you what that means. It's going to be different for each individual person. It's going to be different for different age groups. It's going to be different for who you're dealing with. You folks are certainly in a better position to decide whether or not this person has understood. However, the important thing to consider is that it's not just a matter of setting down the form in front of them and having them read it back to you. You're potentially dealing with children 12 years of age or younger, and whether or not they understand. I mean, these forms are drafted by lawyers, and you know, a lot of us don't even understand them sometimes. So setting it down in front of a 10-year-old child, they're not really going to understand what that means. So the bigger question is, can you even use your standard informed consent form, or are you going to have to create different ad hoc informed consent forms to deal with these situations? Final one, which is the most interesting one to the attorneys. This is actually not found in the health section of the statute. This is found in the sections of the statute governing courts and court procedure. This is the informed consent definition if you are ever sued for medical malpractice. And of course, because attorneys are involved in this, we didn't actually define informed consent. We defined the lack of informed consent because that's the standard. And you can see it's kind of a vague definition. It's really more talking about whether or not the person has understood the risks, the alternatives to treatment, things of that nature. It's really more geared toward, the definition anyway, is really more geared toward physical ailments than mental ones. But nonetheless, this is the definition that would apply even for medical malpractice in a mental health standard. But the interesting part of this statute is the second part, which is not only that you've explained the risk, that you've explained the alternatives, anything foreseeable, but the second part is the patient has the right to ask you any reasonable questions about the treatment, the alternatives, the risks. And if you fail to disclose information required by one of those questions, that's also creating a lack of informed consent. So it's not just you deciding, I've told you everything that there is to know about this potential treatment. I've told you everything there is to know about the alternatives. If the patient has a question and you don't adequately answer that question, then you're potentially creating a lack of informed consent. So again, raises the issue if you have younger patients, 10, 11, 12-year-old patients, how much of this are they understanding when you're talking to them? And I don't know the answer to that question. I mean, I don't know if any of you have any thoughts on that, but how are they going to be able to understand the consequences of their treatment? How are they going to be able to understand the alternatives of their treatment? And perhaps most importantly, from a legal and potential liability standpoint, do they understand what it means when you ask them if they want their parents involved in the treatment or not, or whether they want their parents to know about the treatment or not, or when they're telling you, I don't really want you to talk to my parents. Do they know what that means? Do they understand what that means? Not only, the obvious kind of obviously it means your parents won't know about it, at least for a little while, but do they understand what that means from a clinical standpoint, from a health standpoint? Do they know everything that's going into that? So when you're drafting your informed consent form, whatever form that ends up taking, most of them are fairly standard. There's no boilerplate language, but you all use them now, and it's just a question of how are you going to deal with these issues. Just understand, very few court cases actually discuss the informed consent standard. So from a legal standpoint, it's not really settled law. Not only is it not settled law, but the cases that do describe it are very clear that it's very fact-based, very situation-oriented. What is informed consent in one case may not be informed consent in another case. In the law, we use a lot of the reasonableness standard. What would a reasonable and reasonably competent professional have done in this circumstance? If the reasonably competent professional in this circumstance would have done what you did, you probably met the standard. If they would have done more, then you may not have met the standard. But that's hard to tell on the fly, and unfortunately, I can't give you a great answer right now, but it's going to depend on every situation that's presented in front of you. As I mentioned, and as we just went through the different statutes, concepts not well defined under Vermont law. So when you're drafting the informed consent forms, these are the things that you really need to keep in mind. Nature and purpose of the treatment, risks, alternatives. This is something you guys do anyway as a matter of course, whether it's talking to a 12-year-old patient or talking to somebody who's 45. The important thing that you need to keep in mind for Act 35 is that it needs to be geared toward the understanding of the patient. So if the child is 10 years old, how do you explain to them the nature of the treatment that you're going to be providing, whatever that treatment is? If it's talk therapy, or it can't really be medication quite yet, but what is the treatment that you're going to be providing? What are the alternatives? It's very difficult to explain to the child what that is. If you're providing treatment without parental consent, make sure you document that on the form, that the patient has requested that you do that. The other thing that you're going to want to keep in mind and be very cognizant about when you are dealing with these issues is that it not be seen as you pushing for the child not to have their parents involved, because that's going to come back and bite you really fast. So make sure that you really have an in-depth conversation with this patient about whether or not they want their parent involved. And it could very well come down to telling the patient, you know what, I think you need to think about this more, and then come back and talk to me later. Obviously, that's within your professional judgment whether or not you're going to do that, but it's certainly completely reasonable when you're put into this situation. Another key thing to document on the forms is that you should have the patient acknowledge that it is possible that the parent are going to be able to see the notes. They might be able to see the case notes. They might be able to see the medical records. We'll talk about some HIPAA concerns later on and when that might or might not be the case. However, I think it's important, just to protect yourself, to note to the patient and have the patient acknowledge that just because they don't want their parents to see this, or just because you're trying to treat them even though they don't have parental consent, their parents might see it. And I can imagine that would create some anxiety for some of your patients. I can imagine that that might create some tension, and it might lead some of these children who unfortunately need treatment not to seek it. However, I think it's important that they understand it. Again, all part of the informed consent, making sure that they really understand as best they can what this situation is before you start to treat them. The next portion is also very important. I don't think you need this on the informed consent form. However, you should document in the case notes the basis of your assessment for that child or that patient's understanding of informed consent. Document what you told them, document what they told you, document your opinions, document all of this. Because if something happens down the road and there is some sort of issue with this particular patient and their parent becomes involved and something terrible has happened with this person, and it becomes an issue that you treated them without the parental consent, you want to make sure that you noted in there exactly how you got to the opinion that this child had informed consent. So I don't know how that conversation would look. It's obviously going to be dependent very much on the child and on the patient, but it is important for you to note that. And one thing that lawyers say all the time, whether we're dealing with employment litigation or medical malpractice or personal injury or anything else, document, document, document. Put a paper in the file somewhere. If it's not on paper, it probably didn't happen.
Can I ask you a question?
Oh, yes. I'm sorry. I should have mentioned that. Anytime you folks have any comments, any questions, please let me know, because I don't want to talk for an hour and a half.
So I wonder, so often in my notes, I will avoid talking about an additional party. Mm-hmm. And this makes me consider that it might be important, for example, if a student says, I don't want my parents to know because my dad yells at me a lot, whatever. Mm-hmm. So if I was documenting that because I was concerned about liability, I would put patient said, quote, I'm worried my dad will yell at me or hit me or whatever. In that note, I'm always very careful about that. I rarely put notes like that unless I'm concerned about significant harm in some way. But in this, it's demonstrating the student's understanding, but also the student wanting to invoke their right under Act 35 specifically. Does that put me in more of a litigious situation because now I have documented something about a parent that may or may not be true?
No, because of the way that you phrased it,
Okay.
because you said this is what the patient told me.
Okay.
Certainly, in all of your assessments and in all of your evaluations, you're required to be a little bit of a judger of the truth.
Sure.
So, if there's some aspect of what the patient is telling you that you don't think it's really true, that their parent is doing this or their parent is doing that, obviously dig deeper down into it and document in the case notes if you think it's appropriate. But certainly in circumstances like this, I'm presuming the particular example that you mentioned, we're mentioning it in the realm of the issues that the patient was bringing to your attention didn't, in your mind anyway, rise to the level of abuse or something
Correct.
like that where you'd have to report it anyway.
Yeah, it was more of that concern of that student's perception that they may be made to feel really uncomfortable. Or my dad will say, counseling's stupid and you don't need counseling or whatever. That was kind of that. So to play that out a little more, I see the student for 6 months and then mom and dad split up and then mom finds out about it. Mom's lawyer wants the notes and exercises the right to that.
Right.
And now I've made, again, there's documentation that's now going to be probably part of a different, again, do I have more liability in that situation?
I don't think there's really liability for you.
Okay.
You're documenting that this is what the patient said.
Okay.
Whether it's true or dig down deeper. I mean, I would almost err on the side of trying to convince them to bring their parents into it, because not only is it healthier, which you folks know better than I do, but from a legal standpoint, the last place you're going to want to be in a courtroom is if something really traumatic or terrible happens with one of these patients, and their parent says, "I had no idea.
Yes.
How could you not have told me?" That's a horrible place to be. Not only from a legal standpoint, but just from an emotional, personal standpoint, you don't want to be in that position. So definitely document that. And that's the last point. If available, document the reason for which the parent has not been consulted. If there's a legitimate reason, that's why the statute was enacted, because there was a legitimate reason that the parents weren't brought into the situation. If that reason is there, you want to find out what it is. And you want to put it in the case notes just to say, look, you weren't brought in because the child exercised their right. Here's why. Here's why they exercised it. And in my judgment as the treatment provider, I thought that was perfectly legitimate, and so I continued to treat. I think Caroline probably mentioned this earlier, but I think it bears repeating if she did. Nothing in the Act requires you to treat minors without parental consent. You are not required to do that. So if it's something that you're uncomfortable with, or you're not sure how you want to go about doing it, that's you're right as a treatment provider to not do that. Now, if you're working in a school, it's a little bit different situation, but that's your right as a treatment provider not to provide that treatment without parental consent. So if it really comes down to it, and even though you may have done it for several patients before, but you have another patient that comes in, and for whatever reason you think that this child really needs to involve their parents in the treatment, you don't have to consent to treat them. You can either refer them out or try to get the parents involved, or whatever way that you think is most appropriate. So that's another thing to remember. All right, parental access to records. Most of you know generally HIPAA protects the parental rights to medical records. So if you have a child who's a patient, either mental health, physical health, whatever it is, generally the privacy rule in HIPAA is going to allow the parents to have access to those medical records just as if they were the patient themselves. However, this doesn't apply in Vermont if the person is married, in the military, or emancipated. Pretty bright line rules there. HIPAA's protection of parental rights are based on the fact that the parent is considered the patient's personal representative. So this is an important distinction that we'll get to in a minute for Act 35, but the privacy rule under HIPAA, it doesn't say parents have access to their child's medical records. What it says is the patient's personal representatives can have access to those medical records. And generally speaking, the parent of the minor child is considered to be that child's personal representative for medical issues. So that's why they have access to any of the medical records. However, there is an exception. When the minor is permitted to consent to care without the parent's permission, the HIPAA privacy rule kicks in. The parent is no longer considered to be the patient's personal representative, and they are not necessarily allowed to access that record. Before Act 35, especially in Vermont, there were only certain circumstances where this might come into play. If you have a minor over the age of 12 that is seeking treatment for drug abuse, sexual abuse, the minor over the age of 14 who's seeking inpatient mental health in a hospital, they were allowed to do that without parental consent, so this would come into play. So the question now is, does this exception now apply to all mental health services in Vermont? I don't know the answer to that question. However, what I can tell you is, based on the general HIPAA rules, the answer to that question is probably yes.
So can I ask for clarity?
Sure.
I get the HIPAA top piece of it.
Yep.
It's bullet number 4 that confuses me with the conversation you just had with Sarah about notes.
Yep.
So if this is saying that HIPAA doesn't necessarily permit the parent to access the information records,
Correct.
how would they then get her records?
Well, there's a couple ways to do it. Number one, for instance, in the example that Sarah gave, there is potentially a divorce proceeding later on down the line. So a court order can trump just about everything. So you can get a court order or a subpoena for those records, and that would require you to produce them. So that's one way. Another way is the minor could consent to the parent being allowed to access the record.
Right.
What
I'm hearing.
That's the way it seems to be.
Okay.
However, that's a very thin branch to go out on.
Mm-hmm. Right.
I'm not sure that I am willing right now to go that far, but that certainly seems to be the answer. Other ways are if there is to have access to these records would head off some sort of substantial harm or substantial damage or something like that. The treatment provider is allowed to discuss some of this information with the parent. However, with this Act 35 and just saying all minors, regardless of age, yes, go ahead.
So I just want to make sure I understand that
Yeah.
if I have a parent that there may be a contentious relationship with, and I tell them that their sons or daughters' records are confidential,
Mm-hmm.
then I'm not respecting the HIPAA.
I'm sorry, could you say that again? I'm not sure.
So say I make the determination to not share information.
Yes.
Okay, which does not follow the idea of HIPAA there.
Mm-hmm.
But then if I end up and I've done all the stuff with the kid ahead of time, they know, I always let kids know that. But then I do share it, then I violate their confidentiality with Act 35. So
It
either
certainly
way,
seems
I'm
that way,
kind of
yes.
crossing a line.
Yeah, it's a very delicate position for you to be in, which is one of the unfortunate, I think, unintended consequences of Act 35 and the way it was put in was this very issue. There's some indication that there was a little testimony about the fact that, well, we kind of do this anyway with sexual abuse, and this rule's kind of in place already with drug abuse and things like that. However, I would guess that if the legislatures were told ahead of time, hey, by putting this statute in, you may be cutting off parental access to all children's medical records, I don't think they would have left it quite as broad as they did. I don't think that was their intent. However, with the way that it's drafted, that certainly seems to be how this has come about. If the patient, the minor patient, really truly does not want their parents involved at all, they can, in theory anyway, withhold consent for their access to these records. The parent, could end up going to court, could do all sorts of things to try to get them, but that creates another contentious issue between the parent and the minor, and that's obviously what you're trying to avoid. So it's a very unfortunate side effect of this Act 35, but it looks like that's what they've created.
What about in the situation where, so again, we'll go with the divorced parents and the assumption that they each have access to rights. So mom says yes to counseling, dad says no. The kid can make the decision to say yes. So now we have a parent who would still be considered the patient's representative and then a parent that is not?
No, because in that circumstance, the standard form court order says that the non-custodial parent would have access to any and all medical records. So if you've got a circumstance where the parent has acted as the personal representative of the patient, regardless of which parent it is, then I think that you can provide access to the records to both parents, absent some other extenuating
Fair
circumstance.
enough. I know that's kind of an unfair question.
Yeah. So there's a little bit of a difference. I know the folks in here that either work for schools or at schools. How many folks work for school districts or work for schools? Oops, several of you. Oh, good. Okay. So there is a difference in talking about privacy standard and access to medical records between HIPAA and FERPA. This is something that I used to do a lot of work for school districts, and I think a lot of school districts don't quite understand this. Medical records maintained by an institution that is an educational institution under FERPA, they're not considered medical records governed by HIPAA. There is a specific exception in HIPAA for medical records that are governed by other privacy laws, and that's one of the privacy laws is the FERPA, Family Education and Rights, something or other. I can never remember what the acronym stands for because I called it FERPA for so long. If the records are maintained by the school, then they're considered educational records. Educational records are governed by FERPA. They're not subject to the HIPAA rules and regulations. The important part of this is that if the treatment provider is employed by or under contract with the school, FERPA applies. So even if you are a private treatment provider that is under some sort of part-time contract or some limited contract with the school to provide services to the students, the records that are kept from those services are considered to be educational records. There's a difference between educational record and treatment record under FERPA, but for all intents and purposes, they're governed by FERPA instead of HIPAA, which is important because the other thing is FERPA doesn't apply if the treatment is provided on the school ground. So in other words, if you're a private provider, you're contracted to provide a service, you're not contracted by the school, you're not employed by the school, you're not controlled by the school, you're just providing the service on school grounds, you're under HIPAA still. You're not under FERPA under that circumstance. The difference is who's maintaining and controlling and employing the treatment provider. FERPA's protection to parents' rights are much, much stronger than under HIPAA. Under FERPA, generally speaking, parents are allowed full access to any educational record, which would include, in this circumstance, treatment records. The only real exceptions under FERPA for the parents' access to educational records are if there's some sort of health or safety issue. That's the only issue. So if you have an abusive situation or something of that nature, then you might be able to withhold access from the parents. But generally speaking, even if the child doesn't want their parents to have access to those records, if they're considered educational records because the treatment's provided by a school employee or somebody under contract at the school, the parents can have access to those records.
So my personal notes, if not shared with anybody else, are not an educational record.
Well, who's employing you?
School.
If the school, well, where do you maintain the records?
In my desk drawer.
At the school?
Yep.
Then under FERPA, those are educational records.
That's okay. You'd be the first attorney in 21 years to ever say that.
Yeah.
So I'm not necessarily sure I agree.
It's really different than anything I've ever heard.
Exactly. You'd be the first one in 21 years to ever, as long as I don't share them. Somebody could subpoena them into
Right, yeah.
record, but they're not part of the educational record.
Which is the advice that we've given to schools for a long time. It's not necessarily correct, but what we have told school districts for years was segregate things, bifurcate them, and keep them separate. It's not necessarily the case. So school districts are not necessarily protected by that segregation. The VSBA is not contemplating any policies to deal with Act 35. I contacted the legislative and legal person at the VSBA, and they have no intention of doing anything with respect to Act 35. The VSBA is the Vermont School Boards Association. So you're kind of on your own at this point, at least from the school's perspective. That doesn't mean that you can't enact policies. It doesn't mean that you can't enact procedures. However, the VSBA is not going to help you. One interesting note is that there is a transgender model policy that some schools have enacted, some schools have not. However, it requires the school to maintain confidentiality of the disclosure from non-essential school personnel, which is much the situation that you were describing. If the transgender student decides that they want to disclose this to certain school personnel, they are allowed to do that. The model policy requires that if the person does not want their transgender status to be known beyond those personnel, then the school has to make sure to maintain confidentiality of that status, even from any other non-essential school personnel. To the point of, and it's even in the policy, separate records are required if necessary. So you might have to keep an entirely separate record, one redacted and one not, if there's a transgender student that decides to make that disclosure. Which is an interesting tie-in now to Act 35. How is that model policy going to apply to Act 35? Are they going to have model policies that eventually, are there going to be policies that discuss Act 35 in a similar vein? In other words, maintaining completely separate records? Then not, I don't know. I don't know how that's going to come about, but this is another issue that Act 35 discussed, or that Act 35 has brought up that just people weren't quite ready to deal with yet. The other, I don't have it on the slide here, but the other interesting interplay between HIPAA and FERPA is that if the medical treatment is not provided on behalf of the school, then one of the potential ways around having parental access to the records is by saying that the medical treatment is not provided on behalf of the school, so HIPAA applies. The child has invoked their right to confidentiality. I'm not giving parental access, but the school is still allowing me to use school grounds. And an issue that the school is going to have from that is that if the treatment provider is not providing treatment on behalf of the school, then the school has FERPA concerns on its own. So it's not allowed to give out personally identifiable information to the treatment provider, which could create an issue with providing treatment on school grounds. So we all run in circles here.
What if you have the consent though?
I'm sorry?
If you do get consent from parent, then that.
If you have consent, then
That
you're pretty good. You're good to go. If you have the consent, then the child's representative has provided you with personally identifiable information, or the parent can always give permission to the school express permission to the school to share information about their child with somebody else. So those were the end of my slide presentation. There were a couple other questions that I thought folks might have, one of which is, if you're not having parental consent and the parents aren't involved in the treatment, who pays for the treatment? There are ways for a child with insurance to access treatment without the parent being involved. The difficulty, of course, is that the child's going to have their own insurance information, whether they know that information, have access to their insurance card. There are ways for the child to do that. I have been told, I have never actually seen this happen, but I have been told that for private insurers, they have the ability to send an explanation of benefits to a different address than what is on the insured's file. As I said, I haven't been able to confirm that. That strikes me as odd that the insurance company would be able to do that, but I have been told that they can. Obviously, without that protection, you're going to get an EOB sent to the patient's home. Mom or dad are going to open this and find out, what is this, bill from Sarah White? We never saw Sarah White. What is going on here? And it's going to create a hornet's nest there, which is another unintended consequence, I think, of Act 35 and an issue that hasn't been dealt with. But I'm not really sure what the way around that is right now. If the child has access to Medicaid, it is supposedly easier to protect the confidentiality of the treatment, but obviously it's a concern. And it's a concern that you should take into account when you're taking the patient in during your intake, is how is this treatment going to be paid for? And is that payment then going to subject the patient to disclosure of the fact that they're seeking treatment? Any questions at this point about any of this?
Well, it's interesting because I work for the Williamstown School District, and we have about 9 private clinicians that come to our schools, and we always make sure that we have permission from the parent. They do paperwork, and we always make sure that Williamstown School District is on the release of information so that we can communicate with the clinicians. I'm just kind of like thinking out loud, typically our nurse is the holder of health information and Medicaid numbers and private insurance numbers, and I would imagine that if a student went to their nurse, that's information that they have access to, since that's their information.
Yes, I would assume, yeah.
I think one of the challenges is that, say I have a 14-year-old student that says, would really like to meet with a clinician, parents are not in agreement with that. I could certainly give them the contact information, but like I think you were saying earlier, that student could set up an appointment with that person, but if a clinician comes to the building and says, I'm going to meet with so-and-so, I can't even really communicate with them if we don't have,
not without parental consent.
Not without parental consent. So it seems like it creates a barrier for that student because we can't allow them to meet with somebody that we don't have authorization to have them meet with.
Yes.
So where are they supposed to go? Meet in the parking lot, or it's just to go sit in the car? It feels really like there's so many barriers. And
Well, previously in that circumstance, the child would not have been able to access mental health treatment without the parent's consent anyway. So in a sense, Act 35 really didn't make it more difficult. It eliminated one barrier, just not all of the barriers that might need to have happened. What's that?
Create a gazillion more.
To the extent certainly that the patients become aware of their rights to these treatment options, then that's one of the questions is what do they do? I mean, obviously, children that are 12, 13, 14 years old, they spend a significant amount of their time at the school, and that's where a lot of their resources are going to come from. So what do you do?
Well, and you could probably, based on policy, couldn't let them in and meet alone anyways, right? Because they got to go through background checks and wouldn't be able to be in the building and be alone with kids, right? And I would assume in your building.
Yeah, we certainly wouldn't have a student meeting with somebody that we didn't know about that. Although we might know about it, but maybe not. I don't know. It feels really sticky.
Question around notification of options. So not quite sure, need clarification if that needs to come from like an SU supervisory union within the school to say what is, the best practice? Or is there something there that says that when you are talking to a student around rights, you have to disclose that they actually can access this and give them information on there?
There's nothing in the act itself that requires you to make such a disclosure.
Okay.
Would it be best practice? Ordinarily, I would have said yes. However, because of all of the questions and issues surrounding Act 35, I'm not 100% sure that it is best practice to make that disclosure to the student, saying, by the way, you can access this without your parents' consent. Certainly, I would tell them about the resources available, but whether or not you have an affirmative duty to say, and you can access, this treatment without your parents' consent, I don't think that you have that duty.
Even if it's for the original issue?
I'm not sure I follow you.
Because the act was originally created for LGBT.
Oh, yes.
So if it was for that reason, is that an option that you would give them? But we're not, so what I'm hearing is we're not required.
Yes.
So if we were to, it would have to be something that RSU or administration would feel strongly about.
Yes. Go ahead.
But conceivably, that could be malpractice because you haven't discussed all treatment options with an individual, and there's a bad outcome because you say they don't know that and they walk away.
Right. What are the alternatives?
Yeah.
Yep. Which is part of that whole discussion. Certainly, if the child says, I don't think I can do this because my parents won't let me, or I don't think I could do this because, my dad has issues with mental health treatment, or, something along those lines. Certainly, I think you need to flesh out that conversation and talk to them about what those issues are, and talk to them about whether or not, treatment options are the best thing for them. The legislators, the legislative memo, did Caroline go over the memo this morning that the legislators, their intent was just to have this option out there. Their intent wasn't to bind treatment providers into doing X, Y, Z. However, I think you raise a legitimate issue, which is if you're not telling them about all of the options available, are you doing your job? Which is a good question.
I think to further what you're talking about, Bruce, in counseling, we always think of, how do we prevent the worst, those potential outcomes. So for what comes up for me is a depressed student whose parent says, you're not seeing my kid, and there's all kinds of stuff going on in that house, and they need it. The parent says no, we might not be compelled, but if we don't then tell that student, so here's the thing, your parents don't have to do that, and that student suicides.
Right.
Malpractice, certainly, it maybe not, but certainly morally, I've withheld information. Bring up a great point of, maybe we're not mandated and compelled by law, but yet there are a lot of situations where we would want to let students know. And then, Robin, I also heard you say it's really not appropriate to say, Nana, boo-boo, you can do this without your parents.
Right.
So, not necessarily making it a flag to fly, but an option to be used.
Even if it isn't as dire as like suicide, that kid's hurt, that kid. It's like, I don't know what I do.
I think you'd have to be honest, right? And at least, if you share that the act is actually in place, and I think we would, at this point in time, I would feel the need to go into but here are all the drawbacks and pitfalls in the gray area that's not worked out, right? So yes, we can give you a referral. Yes, you can go, but we got to figure out how it is you're going to, number one, get to and from. We got to figure out how it is it's going to get paid for. right? And if the explanation of benefits gets sent to your house, then mom and dad are gonna know, right? So, I mean, I think it's a pretty lengthy, there's so much gray area that that would need to be explained to the 14-year-old. So like, do they really, I hate to say it, do they really,
Can they give informed consent at that
can they
point?
give informed consent? And does, I hate to say this out loud, but I'm gonna say, it's a well-intended act, right? But like, it's not fleshed out enough to actually like work.
To give it cause more harm than good.
But I think you're right, if you do have to tell them, you have to tell them the pros and the cons, which is all part of our informed consent. And then you get back to that, do they understand, you know?
And even if you can pay out of pocket, mom and dad get divorced in 2 years, they figure it out, then right, they can still subpoena the notes and like they're gonna figure it out anyway, right? Like, yeah. So like, how do we just have the conversation around
That
getting your parents on
of
board?
all of the consequences, which are, teenagers aren't great at seeing the consequences down the road anyway.
And just to add to what you were saying, in a malpractice circumstance, if you're talking about a potential malpractice action, the standard is, what would a reasonably competent treatment provider in your position, what would they have done? So if 2/3 of the folks, you all seem reasonable, if 2/3 of the folks in this room said, in this position, I would have told the student X, Y, and Z, then that's probably what the standard's gonna end up being, which is not terribly helpful to you when you're find yourself in that position, but that's what the standard is. So, I think not necessarily leaving it to the legislature to fix the problems, although I guess they're going to give it a shot. But if the mental health professionals get together and the associations that you folks have and the groups that you folks have start dealing with these issues and start putting out, these are the standards that we think should apply, or these are the protocols that we think should apply, or this was what we would consider to be best practice. Generally speaking, the legal industry is going to abide by that. So all of these things, not to throw them back on you, but all of these things are obviously folks like you should be considering and discussing amongst yourself. What is the best way to approach this? Yeah.
So I'm thinking about, so say, I agreed to treat a 15-year-old, and I don't have to worry about billing insurance and stuff like that. What about waiver of confidentiality? Say we want to try to talk to their primary care physician or something. Mm-hmm. Any thoughts about how that works?
If you're asking the student to waive the confidentiality?
Is that legal? Or is that like, exactly?
Anyone that has a privacy interest can have an affirmative waiver of that interest if they have the capacity to understand what that waiver means. In that circumstance, if you have, your average, whatever average means, but you have a teenager that you think has the capacity to be able to waive their privacy right, then I would certainly encourage you to document the basis for that opinion, making sure that you have thoroughly discussed that issue with them and making sure that they really understand what that means to waive that right. I'm not sure in what circumstances that would arise if you personally wanted to talk to their PCP or.
If I was providing treatment, a lot of times the primary care physicians, prescribe medication and they rely on me, who has eyes on the kids a lot more,
right,
to kind of like monitor that.
Okay. So in the circumstance you're describing, we're assuming, of course, the parents are not in the picture.
Right. Yeah.
So what happens then?
Picture. Who usually sign the consent?
So in that circumstance, where you're starting to veer a little bit out of mental health treatment and into the more physical health treatment, and Act 35 only applies to outpatient mental health treatment. So, when you're talking about medication and things of that nature, then you might be outside of Act 35 strictures.
So it says that the kid can access mental health treatment. It doesn't say that the treatment provider can then speak with anybody else. We would still need parental permission to do that.
Correct. Well,
right?
Because of the way that HIPAA is written, then the HIPAA privacy laws protect the patient's privacy. And the patient can waive that if the patient wants to protect it. You obviously
But not the
cannot.
patient's 14.
Again, that's because it specifically accepts the fact that a minor can consent to waiver of their privacy rights if state law allows the minor to consent to treatment by themselves in the first place.
It does.
Yes. Well, it doesn't specifically say the minor can waive their confidentiality right, but there's no exception to the general rule that you can waive your confidentiality rights if you're a minor.
Okay, so I'm a 14-year-old.
Yep.
And I'm seeing Todd.
Mhm.
And my parents don't know it.
Yep.
And I go see Elizabeth, who's my primary care physician,
Mhm.
and I say to her, you, Elizabeth, can talk to Todd. I'm gonna think reasonably the odds are pretty good that the physician, without a parental release, is not gonna talk to Todd.
I would agree with that.
Okay.
Yep.
Just because I, as the minor with informed consent, says she can, that probably is still.
Yes, for the physician, that's going to be the case because the physician is not necessarily a mental health provider.
Right, but so if I tell Todd he can talk to Elizabeth and I'm 14, right?
Assuming you understand and have the capacity to understand, which is the treatment provider is going to have to make that assessment and determination. And if you don't think they really understand it, then they haven't waived anything.
But if Todd thinks I understand that it's okay for him to talk to Elizabeth, you're saying legally he can do that without my parents' permission?
I'm saying it's certainly possible.
So you can make a clinical decision, talk to me, the doctor will say, you can say whatever you want. I can't confirm or deny that this person's a patient or I have any.
Right.
I can't give you any information.
Right, and then my two parents sitting
Uh-huh.
here, when
Right.
something happens, can then sue him because they didn't give permission for him to talk to you.
I'm gonna call Robin.
You're gonna be busy.
Well, remember, this is what I talked about, that really thin branch to go out on.
Yeah.
It's a branch, personally, I would not want to be there. Now, I'm not a mental health provider, so luckily for me, I don't have to go out on that branch. But you may find yourself in circumstances where you think that providing treatment to this patient is so important that you might have to go that far. And if that's the case, document it, certainly document it. If you obviously suicidal ideation, things of that nature, you're gonna have to make that judgment call.
So it's, yeah, we have to share that.
That's, yes,
Right,
sorry,
yeah.
that's harm to the self. But, if there are certain circumstances where you think that it is so important that this patient receive treatment that you're willing to go out on that limb, there's at least a legal basis for you to make that argument.
Can I ask a question?
Sure.
So, would mental health screenings be considered outpatient treatment, meaning psychotherapy and supportive counseling, or is that a separate category?
Mental health screenings,
So for
meaning,
emergency, when we have students that are suicidal in our office, for example, if I have a child that comes in and is, needs to be screened by Washington County Mental Health, then I have to call the parents to get permission for that to happen. But would that fall under the umbrella of supportive counseling, outpatient treatment? Because they're not inpatient at that point.
right, that's a good question. I don't know the answer to that off the top of my head. The first thing that springs,
So the first thing that comes to my mind is Impala laws that would allow treatment in a life-threatening situation
Yeah,
regardless of
emergency.
consent.
Yeah.
However, if you have that much of an emergency, you're going to have called police and an ambulance. Like you're going to have like a
Right.
first responding situation where you're off the hook because you got to provide safety. So EMTALA comes to mind first,
Yep.
but often with screening, it's not that kind of situation. There's, a crisis afoot, but it's not at the moment life-threatening.
Because of the child, even if they're screened in and have to go to inpatient, they still have to give permission.
In Vermont, right? Robin, they still
Yes.
have to provide consent
yes.
for that.
They have to give consent.
I can't have consent too.
if they're
Right,
ready to go.
yeah, I mean, it's a long process if they don't.
Yeah.
Okay, so like many times, look, I'm responsible for like mental, safety screens, and I want to let the parent know if I'm sending the kid home. And so now, and I guess what you're asking, right? So now I do a safety screen. It's not like hospital material, but I'm concerned the kid needs support outside of that. Says, let's talk to your parent. You can't talk to my parents. I want to talk to my parents.
So in that circumstance, what's the treatment that you're providing to the child at that point? At that point, you've made an assessment.
Yeah.
And then you're sending the child home, the student home?
If it's not at a level of hospitalization,
Mhm.
okay, it's like low risk, we use the screening device for that. But usually at that point, we notify the parents, talk with the parents about, measures, observation, removal of stuff, checking, see if they're guns in the home, things like that. And the kid says to me, my dad would be really mad at me if you call home.
So then what do you do? Do you call home? Yeah.
Yeah.
Do you have health or safety concerns about sending the student home at that point?
Oh, yeah,
That's your
Yeah.
breach.
yeah, okay.
That's your
All right, I
safety
just
breach, no
wanted
matter
to think
what.
that through.
Because
think-
what's the alternative? If you did not let that parent know and something happened to that kid, now you're on the hook.
Yeah.
So I guess I wonder if the piece would be like, for example, there are times where the screeners would have come to school because we can't reach the parent. We don't have the authorization to transport them to the hospital or the mental health facility or office. So I would wonder if we would do the transportation. I mean, we would have to do one thing, right? But we're able to have the screeners come to the building without parent permission.
We've had screeners come to the building only because we could not get the student to move. The parents were on board though. So mostly for the screening, parents have to be on board. We have transported the parents. Yeah. But the do warn always in any of those situations, my recommendation is you call the parent, whether they're going to be in trouble or not.
Or screened out, I guess. But actually getting permission to have them screened, because there have been times where parents have not given them permission.
We get that a lot too. I thought this was going to help because if the parents, we say our recommendation, strong recommendation, we're documenting, strong recommendation. However, they never bring them. They never bring them. They never bring them. There's nothing you can do.
When the child is saying, I want to.
And yeah.
So in that circumstance, I think that's the type of circumstance that the Act was specifically put in to try to address.
Yeah.
However, the Act is just talking about the access of that patient to the mental health treatment provider. It's not necessarily talking about getting them there or any kind of transportation or any of those circumstances. So, in that circumstance, because you're dealing with the school district, you're really kind of put into a difficult position because it's hard to bring the treatment provider to the school without involving the parents in some way. And it's hard to take the patient to the treatment provider without involving the parents in some way. However, if it's just a question of could the student have access to mental health screening, even though the parent says no, I think the purpose of the Act is to say, yes, they can. I wouldn't want to be the principal in that situation, getting the phone call from the parent. However, that's what the statute was designed to address. Any other questions?
It's kind of odd that Vermont is deciding that they want to help these kids and they put this in, and it doesn't truly help. And on the other hand, all this help that's there for them, they can say no to.
Yes.
Is so mind-boggling when you're trying to help these kids. and the families. It's just,
Yeah, that may have been a better issue for them to try to tackle initially
yeah.
than this one, but
Exactly.
that's fraught with a lot of other concerns, and not just for children, but involuntary treatment of adults too. So,
Well, and without the Vermont School Board Association jumping in some way and helping out with coming up with a model policy or procedure,
yes,
that's, I don't even exactly even know how to read that, to be honest. Because what that is, potentially bringing on is everybody doing it a different way,
Yep.
Which is going to potentially create an even worse situation, even more violent situation.
Yeah.
Or that nobody does anything.
or nobody does anything. I think that's more likely
Yeah.
because, like, as we've discussed, the act doesn't require you to provide treatment. So I think initially what's going to happen, especially for school districts, is they're going to say, we need parental consent, period. We're just not going to do this. Which is really unfortunate because that's the very children that you're trying to help with this act are the ones that are going to get left in the cold there. But I think that's the more likely circumstance.
I was gonna say though, I think at the same time for like the 16, 17-year-olds who are driving and have jobs out, and out of the house and have access to all of that, they might not otherwise know. So that's the population I see accessing.
Yeah, it might be like sliding fee scales or pay for it out of pocket.
That's a good point. For those kids, this can really help. With 16, 17 plus.
It's a great case, a great example of how important clinical consultation is. You talk about that thin branch.
Yep.
And how important it is to make sure that our teams and school districts know that this is a real thing. And like Caroline talked about this morning, pretending that it's not a thing is an option. It's probably not a great option, but it's an option. But more proactively, talking about how are we going to respond to this and in what situations and how, and then who are our people. So as the homeschool coordinator or the school counselor, who is your consultation team that can weigh in? So then that thin branch, you're not out there alone.
Right.
You're out there with a principal, an administrator, another a clinical mental health counselor, or somebody. You've got a true team, so it's not a silo of let's just do that, but it's lots of documented opinions, so that on trickier cases that there's clear footprints in decision making that have been ethically and legally addressed. So compiling those teams would be, I think, a smart idea for all of us, those of us in the private sector, to have our consultations with consultation folks in schools as well.
Right. So we have a little bit of time left. Let me throw out a couple hypotheticals. And we'll just see how I'm going to question folks. So say you're working with a particular patient who has parental consent. You've been working with this patient for a while. And the patient's 15-year-old friend calls your office. Says, I'd like to come in and meet with you. This is something that I would imagine the school folks see quite a bit, actually. 15-year-old's friend comes in, says they want to talk to you. I don't want my parents involved. What's your next step? What do you do at that point?
We talked about how you could get the parents involved in a safe way first, and try to see if you can negotiate a way for that child to have the services and have their parents be aware.
You get a different answer based on location, right? As a school counselor, they have access to us, right? They just
walk in.
Right, and we don't inform parents, right? If we're part of the educational landscape, and it's a comprehensive program, and it's just another day at school.
Right. Okay. So say the 15-year-old is now 10. How's your conversation different? Is your conversation different?
Not as a school counselor, probably.
How about your informed consent conversation? that gonna be different for a 15-year-old versus a 10-year-old?
Language.
Okay. Now, how about the person that contacts you seeking services is no longer a 10-year-old friend, but is the person's 7-year-old sister? So now you've got a sibling of a patient who has their parent involved in their own treatment. In your estimation, the parents of that sibling have been very helpful in the treatment for the other patient, but 7-year-old sister doesn't want their parents involved. For whatever reason, you can fill out the hypothetical, but how does the conversation go at that point?
Same in school.
Right, yeah, it's kind of an easy answer for you.
Easy answer.
Yeah.
As a private practice, I don't work with siblings, so I would try to find that, somebody else who would explore that with her.
Okay.
Because it would be conflict.
All right.
Let's say I have to talk to my supervisor.
We're going on that limb together.
And obviously, I don't have the answers to these questions, but, it's something for you to think about, that these are circumstances that when they've come up before, you haven't really had to think about them as much because, it was always, okay, well, we need parental consent to do this. You don't necessarily have to have parental consent now. Yeah.
So one situation that comes up for me in private practice is divorced couple, 50-50 people, one parent consent. For the most part, I'm conservative, and if they both don't consent, I don't treat the kid. This is kind of my out to treat the kid if I can justify that this kid is in need of treatment.
Yes, it's one out. Generally speaking, if each parent has the rights regarding medical treatment of their children, you really only need one parent's consent. You don't need them both. However, I would certainly err on the side of getting both parents' consent, and if they don't consent, then I'm not sure that I would take that patient either, because you're going to have one parent that says, little Johnny can seek treatment during the weeks that he's with me, and then you've got the other parent that says they can't seek treatment on the weeks that he's with me, and that's going to create a ping pong scenario. But the answer to your question is, if the child wants to seek the treatment, then in theory, yes, you can provide it.
Robin, would you recommend, maybe more specifically for those of us in the private sector, that we have a specific Act 35 form that we put in our file where a child could say, I, John Smith, enact my right under Act 35 to seek counseling, and I'm giving my informed consent?
I would definitely have at least additional language added to your current informed consent form regarding the involvement with the parent, that the child is specifically electing not to have their parent included in the treatment, things of that nature. Whether you make it a separate form or not, it's not a bad idea. The one part that I would caution you on is what we were talking about earlier, in that an informed consent form for a 15-year-old is going to look a lot different than it will for a 9-year-old. So you may not be able to have just one informed consent form. I don't know the answer to what to that question at this point. It's hard. It's going to be an individual circumstance. So the other question I have for the school folks is, you have a student that comes in and says that they want to have mental health treatment. They don't want their parent to know anything about it. At that point, you folks provide some sort of service with whatever treatment you think is necessary to the student, or do you not at this point?
So as a school counselor, we're licensed to do short-term counseling, 6 to 8 weeks.
Yep.
Luckily, in my school, I have a social worker. So if after 6 to 8 weeks, we haven't rectified whatever the issue is, then I can just make the introduction 4 offices down to the social worker, who can then provide services without the parents needing to know.
We have a similar situation. We moved it over to the SAP, who then can do counseling without parental consent. Thankfully, the issue involved substance. So that was our way. Each case by case, you can get creative. You just have to make sure as a team and including administration and everybody that you're okay with the decision.
So I would be the one they would come to. I'm the social worker. Move it on, I can't kick it down the road.
Right.
And that's why I'm here, okay? Because up until this point, I would say I can meet with you once, understand the situation. After that, I cannot meet with you without parental consent. That's real easy to do.
Mhm.
Well, not easy, but it's clear.
Yes,
And now I can't do that.
you can.
I
You don't
can't.
have to.
I don't
Yes.
have to.
Act 35 doesn't require you to provide
Right.
treatment.
So the difference between outpatient and school is there.
Is there a difference between being an outpatient and being in the school?
In the private, you've said private community therapist.
For purposes of the act, no, there is not a difference. It's outpatient mental health treatment.
No, or so like, because you have told community providers, I think I've heard pretty clearly here today, that you can choose not to.
Yes.
And you're saying the same for school personnel.
I'm saying under the act, you can choose not to.
Right.
Because it is a school situation, it's a little bit different.
We don't know, right?
Yeah.
Who are you employed by?
The school.
So why do you have to have, if you're part of the complementary of educational support services, why do you have to have parental permission to see the kids?
Because I'm a licensed clinical social worker. And that's in the code, that's my code of ethics.
Okay.
Because we've kind of thought this through. I know, and if I was going to talk to you, now I understand. It's like, how do you do this? I want to know.
Right.
Yeah.
And we publicize the social worker as part of the educational process and that they're part of it. So, I mean, we encourage.
are too, but
we
we
encourage
have been advised by our attorneys for our protection, okay? In terms of liability, because it doesn't always go well.
Right. So you have like a separate referral process?
Yes.
Where you open them as a client?
Yes.
Or
Yeah, they're open as client under my license. They're not billed or anything like that, but it's like, so it's
your
it's
contract
different.
with the school?
Huh?
Because you're contracted with the school?
I am a school employee, I am hired by the school,
Oh.
that's the difference. So it's kind of a different credit.
Interesting.
It brings up that great point of the clinical license protection as well.
Yeah,
That, we have boards that we we are accountable to, legally and ethically. So, if we need to consider that. So I heard you say, like, my code of ethics says I have to have informed consent, and I am a licensed clinical
Right,
social
and I
worker.
can
Therefore,
be-
I could be
I can be-
sanctioned.
I can have a complaint filed on it.
Absolutely. That's beyond just what I do in the school. So I think that's a great point to, another place where that intersection of ethical and legal, we need to just be mindful of with, if we're licensed outside of perhaps the agency of education. So great point, Bruce.
So I don't have an answer to you. Someone gave me the answers.
Sorry, I thought you were going to add to that. So if you have a specific code of ethics that requires you to seek parental consent in order to provide the treatment or the services that you're providing, I think that that's going to go. Because I don't think the act itself, I don't think the statute is going to change what your code of ethics, which, to put another way, to put in a legal parlance, that's what a reasonably competent professional in your position abides by. So I don't think the act itself changes. Certainly doesn't change what the code of ethics is, and I don't think it changes your requirement under the code of ethics. It potentially provides a different option if you don't have a code of ethics that says otherwise.
I haven't reviewed the social code ethics in a while, and does it
That's how we
say
understand it. And
parental
then again, with
consent,
our
or is it
legal.
informed consent?
That's the way our school attorneys. But that, it is on our
There's a
list.
lot of little.
Yeah.
Now we're all gonna look at these
I know.
things you gave us
The
earlier.
social worker one is like this big.
Yeah, so you think about, right, like which one do you, so if that's your ethical code, but the act says differently, like, does one supersede the other? Or do you say that
But
the
how is
ethical?
that if you're not hired in that position? That's not what the school is requiring. It's
Right.
different if they market you and it's part of your job responsibilities
To
to
provide any service
to
regardless of.
provide a specific service, whether it is a school counselor, whether it is a SAP or a social worker position. That's what kind of confuses me, is what you're hired as, that's your responsibility within that school.
Mhm.
So even if you have a license, but you're hired as a guidance counselor, how does that trump? Because you all have a license that you would have to provide service in that other capacity with the legal and ethical things backing it up.
Well, I can't speak to the individual ethics requirements of what would be required of a licensed clinical social worker if they were not being hired as a licensed clinical social worker. If they were being hired as just a general guidance counselor or something of that nature. I don't know how the ethics would play out. That's certainly not my area of expertise. So I can't speak to whatever your governing board would do. However, from a legal standpoint, I think you're still on safe ground. I think the school is still on safe ground in saying we need parental consent to provide X, Y, Z, subject to health and safety and those kinds of things.
But it would be good to get the school board to adopt a policy.
It would be good, well, there's danger when you have school boards going out and adopting their own policies. I used to serve on a board for 5 years. I was on an SU board for 5 years as well. When we went off on our own, we found more trouble going that way.
But there's no boilerplate.
There's no model policy.
Correct.
It doesn't sound like there's much talk about adopting.
There's no model policy and they don't contemplate formal.
Okay.
Which then leaves it to potentially the school boards to create their own.
Right.
Which,
Or not.
Or not.
Or not,
Right.
yeah,
and
I like that.
And it comes back
I
on
do
us.
think honestly it's gonna be more likely that nothing is done, because there's just too much question about liability. And also just PR. I mean, again, I go back to, we're a public institution, and so there's that risk of doing something for our constituents that is seemingly, not collaborative or not honest or just not pure. Even though our intentions are very much pure, but I think there's a lot of liability.
Certainly. And I don't know too many administrators, although I know a few. I don't know too many administrators that would be all that comfortable with being in the position where, did you know that such and such school is providing mental health services to your student and they're not only are they not getting your consent, but they're not telling you anything about it? That would be a tough position to be in. Obviously, it's different, especially in a school context, when you're talking about harassment and bullying. If you have those types of circumstances come up, you're required to investigate those, but which obviously touches a lot on the mental health aspect as well. And you need to conduct the investigation however it's best to conduct the investigation.
Yeah, I think the typical, at least in a school, the typical real life situations that come up where this would come into play are either the adept student coming and asking for mental health therapy without their parent wanting to be involved, or you've asked the parent for, you've made the referral and the parent either doesn't follow through or refuses that access, and the student still wants to seek that. But again, from the school's perspective, without some kind of insurance policy from a school board association or something, I think that's gonna be a really hard line to cross.
Is do you continue to the kid or not? I think from the school's perspective, they're gonna say, don't. If the parent withdraws consent. The more interesting question is, what do you then tell the student? You can then tell the student, well, I'm sorry, your parents no longer want me to see you, and so the school cannot provide this treatment for you. Do you then go the next step and say, however, you can see these people. You can see Sarah White. You can't,
I think about client abandonment too, for that.
Yep.
For that parent who takes away, but client wants to continue as a private practitioner.
And I think
Legally,
you,
if you can, but you don't.
Yeah. I think you really have to rely on your judgment call in that circumstance. What are the patient's needs? If the patient's needs are dire enough that they really need treatment, and in your judgment, they really need treatment, I don't think it's going out on a limb to say, well, you might want to talk to these folks. You don't necessarily have to say, your parents don't have to agree, they don't have to do this. You could say, I can't treat you anymore. Maybe you should call these folks.
Google Act 35.
Good, yeah.
Robin, one last question. I'm wondering, given that we probably won't see anything from the legislature this session, but how do we watch? Obviously, we didn't really know that this was happening. So how do we watch for updates, and how would we know if there were changes?
Well, the hope would be that your lobbying and association folks would let you know.
Well, that worked well last time.
That didn't happen.
Are there? Those folks exist?
They do exist.
Okay.
They absolutely do exist.
So generally speaking, there's a way to track any bill in the legislature that's coming down the pipe. You go on the legislature's website, any bill that has been introduced, you can take a look at it. The unfortunate part is that they're identified by number and by title, and the title may or may not tell you what the bill is actually about. And even beyond that, once the bill has worked its way through the legislative session, it could be totally different than what it was 2 months earlier. So if you hear about something, if, for instance, if Caroline or I heard about something, we let you know, hey, we heard about this bill. Certainly you can follow that on the legislative website. Any changes in the bill, any hearings that are coming up that you might want to testify at, it's all on the legislature's website. That's, I'm going to say the easiest. That's not really the easiest way, but it is the clearest way to track any legislation going on. Another way would be to contact your legislator, whoever that happens to be, the senator or the representative, and say, they may not even know about Act 35. A lot of times this stuff goes through and they don't really understand what they're voting on. Hey, Act 35 went in last session. I'm a mental health professional. I want to talk to you about it. Here are my concerns with it. Hopefully that legislator will either agree with you and try to do some work on their own to address those concerns, or talk to the representatives that put in Act 35, that actually proposed it, and talk to them about any additional legislation that might be necessary, and then they can help you track it. So there are ways to do it. Unfortunately, there's no quick and easy way.
Any last questions for Robin before we break? All right, thanks, Robin.
Okay, thank you.
All right, go ahead and take a break. We'll be back at 2:45. Finish up.
Information in the